Hello, Dale McDermott here with the CGLCC, and welcome to the 2020 Digital LGBT Plus Global Business Summit. Before we get started on the session, CGLCC would like to recognise our presenting sponsor, TD Bank Group, along with all of our gold and silver sponsors and all of our sponsors for helping us to make this event happen. We would also like to recognise our translation partner, AI Media, for enabling us to deliver live caption translation in 3 languages, English, French and Spanish, and you can access those using the links below in the description box. I'd also like to draw your attention to the left-hand side of your screen to the networking and exhibit hall tabs, where over the course of the next 5 days you can connect with LGBT plus businesses, corporations and each other to help drive that power of connection. And finally, if you do like the content we are producing, please feel free to make a financial contribution using the donate link in the description box below. Thank you and enjoy your session.
Please enable your microphone. Thank you.
Sorry, I think our moderator may be having just a bit of a microphone issue.
Warren, do you want to start?
Yes, sure. I will be happy to start. I hope that we can resolve this soon, but welcome, good afternoon, and welcome to Gowling WLG's session entitled The Legal Implications of COVID-19. Today, our panel will explore certain legal issues facing businesses as a result of the COVID-19 pandemic. Specifically, we'll be looking at these issues from an employment, municipal planning, and corporate commercial perspective. Before we begin, I would like to thank the CGLCC for inviting us to speak with you today, as well as for creating this space that allows our unstoppable LGBTQ plus community to come together and to support each other in business. Our session today adds to a long list of webinars and articles that Gowling WLG has prepared concerning the impacts of COVID-19 on businesses. The next couple of slides, we've listed some of our past and planned webinars. They're free to attend through our firm. So if any of them appeal to you, please get in touch with one of us, and we'll be happy to send you an invitation. If you missed any of these topics, but they appeal to you, all of the past webinars are posted on the Gowling WLG website. Because we're lawyers, we have to do legal disclaimers. They're kind of our thing. So here we go. Today's session will be a high-level overview for general information purposes. It's not legal advice. Every business and every situation presents unique sets of facts, and those facts are important in determining exactly what legal considerations are relevant. Additionally, as you know, the situation is evolving quite rapidly. So We're only able to present on the laws and practices in effect as of the date of this presentation. As you know, for up-to-date advice, you can reach out to us or contact your legal counsel. And now for our panel. Participating in today's panel, we have Nina Gupta, a partner in our Waterloo region and Toronto offices, specializing in employment and human rights law. Peter Gross, a partner in our Toronto office, specializing in municipal planning and development law. Peter Dolman, a partner in our Toronto office, specializing in corporate law and in particular, mergers and acquisitions. And myself, Warren Cass, an associate in the Toronto office, specializing in corporate and securities law. Our panelists all have extensive experience in their respective practice areas and have firsthand experience in providing legal advice to people and companies trying to navigate the disruption caused by COVID-19. In today's session, we plan to take stock of the current environment and developments that we expect as we move into recovery mode, highlight some common issues that businesses are facing or may soon face, discuss practical measures that businesses can implement in order to weather the storm, shorten recovery time, and get ahead of future challenges. So we would like this to be an informal and interactive session, and we'll encourage you to ask questions throughout by using the message feature at the bottom right-hand side of your screen. Just click the question mark, which appears in a gray circle above the message box. We will do our best to keep an eye on this and to incorporate your questions into the conversation. We'll have a few more slides, but later we'll be taking the slides down so that our faces appear more prominently on your screen. On that note,
Warren, I'm trying to see if my mic now works. Do you hear me? Okay, perfect.
Our trusty moderator is back online. Peter,
I am back.
Over to you for the first question.
Warren, perfect timing. So, panelists, since the World Health Organization declared the COVID-19 outbreak a global pandemic, we have seen our various levels of government issue states of emergency, implement public health measures like physical distancing, force the shutdown of businesses not deemed an essential service, as well as suspend public and administrative services, including court and tribunal hearings. Now, how has all this affected businesses' legal relationships? Nina, let's start with you. As some of the most important legal relationships for any business are the relationships that it has with its employees. Salaries are also tend to be one of the largest expenses and are therefore front and center when businesses are forced to consider cost control mechanisms. What trends have you noticed during the pandemic?
Excellent question, Peter. First of all, what I've been practicing for over 30 years, and so I want to put this in context. I have never seen the number of layoffs, wage and hourly wage and salary reductions, reductions of hours, and actual terminations in such a concentrated time period. So this far in a way is more serious an economic hit to employers than any of the previous crashes I've been involved with. So we have, since March, I would say actually from the beginning of March onwards, had a number of employment law resources for employers, and that is listed on slide 7. And you'll see some of just a sampling of some of the things that we have, all of which are accessible through the COVID-19 website location that Warren showed you earlier. And it's an important resource. So what we've seen, and is interesting, is that typically after a certain period of time, a layoff becomes a deemed termination, and the employer has to pay at least statutory notice and in Ontario statutory severance. What Ontario has done by way of regulation on May 29th, 2020 is unprecedented, and it has essentially said that those deemed termination provisions do not apply to the vast majority of layoffs that have been triggered by COVID-19. Quebec permits layoffs for up to 6 months already under their civil code. So this is not an issue yet in the other large province in Canada, but we'll see what the rest of the jurisdictions do. Again, this is unprecedented. The other thing, Peter, that I've seen is a heavy reliance on government programs. And I can only list them on slide 9. We have slide 8, we have the resources from the government itself and some of the excellent sort of summaries that the government has put together. And then on slide 9, we've also put in some helpful resources from prior webinars and newsletters. But we've seen the Canada Emergency Wage Subsidy that gives certain employers up to $847 a week per employee if they've gotten a certain hit. We've seen the Canada Emergency Response Benefit, $500 a week to individuals who are unemployed due to COVID-19 or post-COVID-19. The Canada Emergency Student Benefit, because many young people, summer jobs, camps, and activities and internships were all canceled. And we know there's going to be heavy reliance on EI as the COVID-19 economic pandemic continues to run its course. The other trend, Peter, that I've seen is a unprecedented, I use that word, frequently because it is unprecedented, at least in my career, focus on return to work safely and reducing workplace hazards. We're seeing business owners and HR professionals get into the weeds about the physical layout of cubicles and office space, have detailed discussions regarding whether employees can even come back to work, given that daycares and childcare institutions were suspended. I know that in stage 2 in Ontario, they will start reopening, but many parents are still concerned about that. We've seen numerous efforts to try to navigate around health anxieties and health conditions. Numerous calls about, I had an invisible disability. I suffer from asthma. I suffer from diabetes. I suffer from COPD. And yes, I've pretty well managed it without any problems, but I don't want to come back into the office. What can you do for me? This also extends to concerns, and not surprisingly, to employees' loved ones. And so you see real concerns about people coming back to work and infecting a vulnerable child, a vulnerable spouse, a vulnerable parent. And so the return to work process has become a very complex one involving engineers, cleaning staff, employees, and unions. And on slide 10, and I can't sort of delve on any of these in too much detail, I've actually given you some excellent resources, and I highly recommend the top one, the infectioncontrol.tips, because it is a plethora of training materials, printable materials, and templates to return to work. And also, I've given you links to some of the government and NGOs that are really helping employers figure out how to return to work. And finally, and somewhat surprising to me, and I guess I'm a lawyer, I follow the rules, is we've had a whole bunch of discipline issues arise because people don't want to wear masks or face shields. Some of them have legitimate religious or medical reasons, but others just sort of feel it to be impinging on their freedom. And so we've had that whole panoply of how do you discipline someone about something that seems to be trivial, i.e. I don't want to wear a mask or I don't want to wear it properly, but which causes such great concerns in the workplace. So very complicated days, Peter.
Thanks, Nita. And at this time now, our presentation can come down so we're more prominent on the screen. Warren, from a corporate commercial perspective, how has COVID-19 affected businesses' legal relationships? And what are some of the questions that businesses can start to ask themselves as they start to move towards a stable recovery?
Thanks,
Warren?
Peter.
Oh, yeah.
No, I've got the mic on now. the primary focus that we have seen from a lot of businesses is that they're really keen to mitigate the financial fallout and to preserve their key business relationship as we come through this time. Cost control has been front and center for a lot of businesses, as Nina referred, to layoffs and furloughs of employees have, been a major strategy that a number of businesses have been forced to adopt. Reductions of operating costs in other ways, deferrals of planned expenditures, capital expenditures, expansions, new product trials and service trials, and specifically the cancellation of contracts, which is something I will come back to in a couple of minutes. We've seen a lot of financing activity, businesses trying to open new credit facilities where possible and to draw down existing ones to have cash in the bank. Businesses that have not necessarily been able to do that have been pursuing additional equity investments and particularly turning to existing investors that already have a vested interest in the business. As noted, there are a whole panoply of government programs that have been made available. Some of the most prominent of which are the emergency wage subsidy, the emergency commercial rent assistance program that requires the participation of landlords, but where landlords participate enables businesses to get reductions of up to 75% of their commercial rent. The Canada Emergency Business Account Program that allows small businesses to access up to $40,000 of interest-free loans, a portion of which are forgivable to cover non-deferrable expenses such as rent and tax and utilities, insurance payments. There are a couple of other programs, the Business Credit Availability Program, the Regional Relief and Recovery Fund Program. If you have not considered taking just sort of a review through all of the programs that have been made available, it's definitely worthwhile seeing if there's another program out there that might be available to you to access government support. But one of the biggest sort of tech support. Would we be able to take down the presentation, please? I think we have it down. Yes, terrific. So one of the biggest issues we've seen businesses dealing with is the issue of contractual breaches. Companies have had their suppliers breach and default on transactions, and they have accordingly not been able to necessarily satisfy all of their obligations. And they've been wondering how they can deal with that. So one of the biggest points in contracts that have received attention is the force majeure or act of God clauses, which are contractual provisions that, where they are included in a contract, excuse a party's performance or permit termination where performance is rendered impossible due to unforeseen circumstances. They don't necessarily, this clause isn't necessarily included in all contracts. So if this is a thing that you might be looking to rely on, the first thing that you'll want to do is look at your contract that is in breach and figure out if there is in fact a force majeure provision available to you in that contract. The common law, the law of contracts, doesn't necessarily imply one into the contract, except for in Quebec, where that is part of the civil code. Once you've found your force majeure clause, assuming you have one, it's important to figure out exactly what it says. These are widely variable, and your rights and the other party's rights will depend on exactly what's written in it. The broad sort of strokes of these are that they include a list of events giving rise to a force majeure event, things like acts of God, severe weather disturbances, war, terrorism, civil unrest. You'll want to look for pandemic or government shutdown or government regulation, act of parliament. Those will be this key sort of events that'll be relevant in these circumstances. The next requirement is usually that the event is beyond the affected party's control and that the affected party could not have taken any possible steps to prevent its occurrence. In order to rely on a force majeure clause, there may be a requirement to give prompt notice to the other party. in order to be able to avail yourself of that. When invoked, force majeure clauses relieve parties from delay or non-performance. And sometimes, but not always, they may give one or both parties a right to terminate the contract if the force majeure event continues and interferes with performance for a set period of time, greater than 45 days, for example. So you've found your force majeure clause, you've looked at it, it seems like it's might be applicable. We next need to do a bit of analysis to confirm whether it is in fact available to you in the specific circumstances that you find yourself in. The force majeure event has to be something that was unforeseeable. If we're talking about a contractual breach that arose in March, maybe in April, an obligation that you haven't been able to perform from that time period when COVID-19 and the shutdowns were still a very new thing, is a much better argument for arguing an unforeseeability than if you were to enter into a new contractual arrangement, now or more recently, where it's not really, a new state of affairs anymore, and it was very foreseeable that COVID-19 was going to interfere with your performance. The next point that I'd want to highlight is that performance must be impossible or near impossible. More difficult, more expensive, not profitable for the business that's performing. These are unfortunately not reasons that will ground an excuse from performance under a force majeure clause. The affected party must have taken all possible steps to mitigate the impact of the effect, and the force majeure event itself must be the direct cause of the company's inability to perform. Now, just to dwell on that for a moment, when looking at an event of non-performance, consider, exactly like what is the cause here of your inability to perform. If you are subject to a government shutdown order, but would otherwise be able to perform if it wasn't for that government shutdown order, then the event that caused your non-performance is the government shutdown order, not the pandemic itself. If you have been deemed an essential business and are permitted to continue operating, then that government shutdown order is not necessarily going to have suspended your particular performance. So it is important to look at that and ensure that it's available to you. On the other hand, if you are performing services like you're an opera singer, you plan to perform and you have fallen ill, with COVID-19, and you are physically unable to attend, well, in that particular circumstance, you would have been prevented from performing due to the pandemic or due to illness. All of which is to say, let's say you've successfully invoked your force majeure clause, the other side agrees with you. The result that you're going to have is that the contract remains in force, but is suspended. The performance is suspended during the period of the force majeure. And you will need to resume performance once performance becomes available to you again. As I noted before, not all contracts have these clauses. So there might be other provisions in your contracts that give you relief from performance if you're not able. Look for delay clauses, excusable delays, unavoidable delays, relief events. You may have cancellation or termination clauses in certain events that are available to you. Let's say you have looked at the contract and unfortunately, none of these things are there. You might have to rely on the common law. There are common law of contracts, termination and excuse from performance provisions that apply under very narrow circumstances. Generally, they apply where due to an event beyond a party's control that was not foreseen, performance has become impossible. So just to return to my earlier example, where you owe personal services to somebody and cannot do that as a result of being prevented from doing that by law or being ill. Another potential avenue is frustration of contract, which is just a related concept where performance remains technically, physically possible, but due to unforeseen events, you or the other party seeking excuse from performance can no longer accomplish its principal purpose of the transaction, and that both parties were aware of this. An example of this might be like if you were hosting a music festival and you had rented a whole bunch of music equipment and from a renter of sound equipment. Let's say your contract doesn't contemplate that public events would be suspended. You could theoretically and technically still rent all that sound equipment, and hopefully you have a backyard to put it in. But both parties here are aware that the purpose of you doing that is completely moot at this point. And on that basis, you could seek termination of the contract. Ultimately, if the other side does not agree to do that, you would be able to argue for that in court.
Thanks, Warren. So what's best from your perspective, to terminate a contract or to temporarily suspend or amend your contractual obligations?
Well, that really depends. The big question is, do you want out of this contract? Do you want this contract to be over? Is it important to your business? Is it easy to replace? If the answer to those questions is yes, it's important, and no, it won't be easy to replace, you might be very important to preserve that contract in effect for when things resume. Typically, we see a lot of companies not really wanting to terminate contracts, particularly where they have good and productive working relationships with the people on the other side of them. And in some cases, termination might mean getting nothing instead of potentially waiting and getting something that you would otherwise be entitled to receive. So what we recommend to our clients is to proactively reach out to the other side on their contracts. And discuss it with them. People have generally been pretty understanding of the circumstances and willing to provide informal sort of restructurings or waivers or extensions for performance instead of instead of resorting to litigation or formal restructuring proceedings, which can be expensive and uncertain. Before you do that, we recommend that you take a good look at what your situation is and figure out what you are in a position to deliver, when you will be in a position to deliver it, what your finances look like. Really, before speaking with a creditor or a landlord or supplier, and getting them to agree to a reduction in payments or a deferral in performance, just have a very good idea of what you're able to perform, because you don't want to be in a position to have to renegotiate that again. Another practical tip is to document everything. All negotiations, discussions, payments, agreements, it all goes into paper. And if you have oral, verbal, a call with somebody where you get them to agree to this, put it in an email to them, immediately after you get off the phone. And of course, reach out to your legal and financial advisors early to develop a strategy to approach the parties to whom obligations are owed. And we are always happy to help on that.
Great. Thanks, Warren. Peter Gross, the relationship between businesses and municipalities is longstanding and of high importance to businesses, particularly small and medium-sized businesses who rely on municipal services. How have municipalities adapted to the current environment, and what kinds of support have municipalities been able to offer to businesses?
Thanks, Peter. So municipalities have been quite nimble in implementing a range of programs and procedures intended to help businesses survive the COVID crisis and hopefully prosper as we move into recovery. I'm going to talk about 4 of these initiatives today. First, municipalities have begun to hold virtual and council and committee meetings that allow for participation by applicants of development approvals and the public wishing to comment on those applications. Public participation in planning matters is a cornerstone of good planning and is a matter of access to justice. Businesses with matters or planning applications coming before council or committees can recognize significant cost savings by not having the representatives and experts sitting through day-long council meetings waiting for their turn to make oral submissions. Rather, they can check in periodically online and only attend when their matter is going to be considered. Second, municipalities across Canada have deferred the due date of property tax installments to later in the year, allowing businesses to hold on to crucial cash reserves. Some municipalities, such as Calgary, are actually reducing previously approved property tax increases and providing tax rebates for those already paid at the higher 2020 tax rates. Third, there are some municipalities, such as Vancouver, that are fast-tracking approval of free permits that will allow restaurants to use public areas as patios to increase seating while maintaining social distancing. Vancouver will process patio applications in 3 days, which is an incredibly short approval timeline. Anyone who has applied for a municipal permit knows that most applications take far longer than 3 days to be approved. Victoria has a similar program that will allow businesses to encroach onto public property to provide a wide range of commercial services. Generally, encroachment on a public property for private commercial enterprise is strictly prohibited, and that's being relaxed in response to the COVID-19 crisis and recovery. Fourth, some municipalities, such as Montreal, are providing low-cost loans to eligible businesses that require less than $50,000 to remain solvent. Generally, businesses looking for assistance for municipal governments should remember that many municipalities, even the smaller ones, have economic development staff whose role is to assist businesses in accessing programs geared to facilitating business within the jurisdiction.
Great. Thanks, Peter. Looking ahead, Nina, how do you see these pressures reshaping the way that we work? And what are some of the opportunities that may be available to businesses?
Well, I want to just actually continue on the theme that Peter set out, which is municipalities. And what I'm now seeing is employers who were absolutely adamantly opposed to work from home or thought of work from home as a perk that some employees might get some of the time are embracing the whole idea of remote work and work from home. And this means that the physical needs of employees in terms of having that home office are going to challenge, I think, land use and how land use is done. And on a personal note, for example, I'm on the process of selling my house here in Kitchener-Waterloo, and I've already been told by the real estate agent that it's Toronto people that are coming in because they are now being told that they can work from home. They don't need to live in a shoebox. No offense to people who love Toronto. They can buy for the same amount of money a mansion in Kitchener, and so that's what people are choosing to do. Another issue is if people are working from home, ergonomics in home offices are going to become much more important. If work from home is a perk, is a privilege, then the employer doesn't really have to worry about whether the chair is right and whether or not the computer screen's at the right level to avoid eye strain. But all of that becomes an issue if it really becomes more mandated and a benefit to the employer. And I believe we're going to see some pressure on how offices and office spaces are used. Finally, what I see is also a cultural change. The cultural change are things like flexible hours, maybe people who are also their kids' primary teacher when we are learning online may not always be available 9 to 5, and maybe we've got to be flexible in starting the day earlier, ending it later, and be flexible with each other. And one thing that has come up quite frequently is if you have valuable office equipment in someone's home, is it secure? Is it private enough? Can we avoid eavesdroppers? Is there going to be confidential information that is inadvertently disclosed? What about financial information, credit cards, and people's clients' personal information? So tons of issues that employers are now thinking about as they contemplate a return to work, but also the post-COVID world, the new normal, if you will.
Great. Thanks, Nina. Peter Gross, what's your thoughts from a planning perspective?
So, Peter, for the last 5 weeks, I've been fortunately, for my family and me, I've been working remotely from a rural area north of Toronto. Now, just 4 months ago, working remotely seemed like an unthinkable arrangement. However, I have found the transition relatively seamless, except for a rather slow internet connection that I'm working on. And it got me thinking about how municipal planning and city building is likely to change as a result of COVID-19. And what changes should businesses, in particular developers, be thinking about now to prepare themselves? As Nina has noted, the employment landscape is likely to change as more employers shift to more permanent working remotely arrangements. Many office workers may no longer have to choose between affordable single-family detached dwellings located in suburban and rural areas with the attendant long, traffic-congested commutes to the urban core, or, on the other hand, smaller condo-type dwellings without necessarily having nearby access to outdoor green space. While housing development in most urban areas has focused on intensification for the last 15 to 20 years, we would expect to see increased demand for suburban or rural housing as remote working arrangements undergo the shift from a temporary measure in response to COVID-19 to a more permanent employment solution. To meet this demand, government planning policies will have to quickly shift their focus from intensification as an overarching goal of municipal planning to allowing for urban boundary expansions to permit more single-family detached dwellings and townhouse development without such expansions resulting either in urban sprawl or a hollowing out of the downtown core. The renewed interest in suburban and rural living in complete communities may be seen in the future as addressing health concerns rather than simply a lifestyle choice. While this shift will inevitably result in more agricultural land being used for housing, this impact to some degree will be accompanied by cuts to greenhouse gas emissions as long commutes to work become a thing of the past for those of us working remotely. For local governments, however, servicing costs are expected to rise as installing services and infrastructure for low-rise residential development is significantly higher than in areas of high intensification. In summary, developers should prepare for this new reality by considering whether they need to change the types of developments they undertake and prepare themselves for increased demand in low-rise suburban and rural development. As for my family's experiment in rural living, we are waiting for installation of a high-speed internet system next week and are seriously considering whether a rural lifestyle might actually become a reality for us in the long term.
Great. Thanks, Peter. It's become very clear that things will be different in the post-COVID-19 reality. One of the recommendations that we as a firm have been making to our business clients is to complete an assessment of risks, both legal and operational, that are impacting or could impact businesses in the next 1 to 18 months, and then try and get ahead of those risks. For example, if your business has essential suppliers, determine if their operations have been affected by COVID-19, and if needed, look at alternative suppliers or a way for your business to cope with an interruption in supplies for the next 18 months. Similarly, take stock of your largest customers and determine if there will be an interruption in them needing your product or service in the next 18 months. Related to this, we suggest doing a review of key contracts. Any business should be aware of whether it or the other contracting party is not or might not in the future be in compliance with the terms of a key contract. If a party is not or might not be in compliance, consider whether the contract contemplates things like penalties or liquidated damages for the performance for the non-performance of the contract? And if so, are there things like cure periods such that a party offside on the performance obligations has time to fix non-performance issues when the other contracting party provides notice? Also consider things like whether there are other liabilities in the contracts, and what are the limits to these liabilities, such as a cap on damages or a statement that there's no liability for indirect damages. Other terms to look out for are, force majeure clauses, as Warren discussed, whether the contract contemplates how to resolve disputes, as well as termination provisions in the contract. Getting ahead of these potential issues is always recommended. Although not guaranteed, we are finding that many parties are being flexible and reasonable, recognizing that COVID-19 pandemic is exceptional, and they are willing to work and come together to something that's agreeable to all parties. The key is to always start early, be aware of the issues, and go from there. Warren, what else can businesses do to help them prepare for the post-COVID-19 reality?
So at this point, I think one of the recommendations that we would have is to ensure that all of your future contracts are going to meet your needs and your capacities. You will have potentially had an opportunity to get very intimate with the details of your contracts over the last little while, trying to figure out how to make things work. And you may or may not have discovered whether your contracts have force majeure provisions in them. Going forward, I think there will be a lot more attention on these kinds of clauses, and parties will want to take a close look at them and make sure that they're comprehensive and relevant. But that said, there are, COVID-19 and the fallout from it are probably at this point pretty foreseeable. So another thing that we're recommending is for parties to actually specifically contract for the flexibility that they need. Consider what is going to be possible, what the payment terms look like. If there are delays due to, events arising as a result of COVID, do you have the ability to give notice and potentially extend the term for performance without being in a situation of breach? That's the kind of flexibility that I'm talking about when we recommending contracting for the flexibility you require. Another thing you might want to look at is any template contracts or standard terms and conditions that you have, and making sure that they meet your needs as well.
Great. Thanks, Warren. We just have a few more minutes left, but I wanted to ask one more question. Nina, from an employment perspective, what else can businesses do to help them prepare for the post-COVID-19 reality?
So one of the things that I'm going to recommend is that people need to look at their contracts and policies now to prepare for the post-COVID era. And also, frankly, if there's a second wave of COVID-19, I don't want to be a Debbie Downer, as it were. We need, and many of the contracts I saw in the last 11 weeks did not have strong enough provisions permitting layoffs or tight language around expectations around terminations, which led to incredibly inflated claims from employees' lawyers. I think if you're going to enter into the brave new world of working from home, you're going to need detailed guidelines, expectations, policies, and protocols regarding home office. And as employers and as employees, I think we're going to have to see some flexibility to really, deal with our other responsibilities, such as daycare, childcare, all of which are important. And I suspect that employers are going to have to really get a crash course in the duty to accommodate. We're supposed to have written policies around duty to accommodate. In the last 11 weeks, I've been shocked about how many companies don't have that. Employees have family responsibility reasons, health, religious reasons, allergies, and chronic health conditions, all of which will have to be accommodated or at least looked at. And then we haven't had much of a chance to talk about privacy, but privacy is huge. I mean, how am I juggling, for example, confidential client communications in between my son trying to do schoolwork and my husband trying to finish his own contract? So again, let's do some homework now so that we are ready for the post-COVID reality.
Great. Thanks, Nina. We are at a time. Thank you all for attending our session. We really enjoyed the opportunity to discuss these topics with you today. Should you have any further questions, please feel free to reach out directly to any of today's speakers. And also, please remember to consult the schedule on the left of your screen for upcoming sessions. And also consider making a donation to CGLCC. You can find information on how to make a donation in the description of each session, including this one. Thanks, everyone, and have a great rest of your day and rest of your week.